so much, Morena, for that sports update. Let's bring you this now. A new court ruling will have massive implications for marriage and divorce in South Africa. The Pretoria High Court has ruled that a part of South Africa's Divorce Act is unconstitutional. This will completely change how divorces are handled when couples are married out of community of property. But to tell us more, I'm now joined by family law expert, Advocate Muhammad Abduroaf. Advocate, thank you for your time and good morning to you. Please keep us up to speed with what this new court ruling actually means for married and divorced couples.
Good morning. Thank you for having me. I hope my video is working. But nonetheless, a very fundamental and a very interesting judgment that has been granted last week by the Gauteng High Court, something which I think is about time that they have implemented and start using the Constitution to the benefit of people out there, especially people that have not benefited or have been disadvantaged in the past because of a lack of fees, lack of money, and also lack of resources. Nonetheless, what the Gauteng High Court said last week was that people that were married out of a community of property without the inclusion of the accrual regime, once they have started divorce proceedings, it is possible for you to claim certain assets from the other spouse. For argument's sake, in terms of our current law, if you are married out of community of property without the inclusion of the accrual regime, you are not entitled to any assets of the other party at all. But however, in terms of the current judgment, it is possible, it would be possible in the future for someone to approach the court and saying, Judge, court, I am now in the process of getting divorced from my other spouse. I am married out of community property without the accrual regime. I'm not entitled to any accrual in terms of the law. However, in terms of justice, fairness, equity, because I have contributed towards a marriage, I have assisted my spouse in becoming wealthy, the person that spouse is today, I would like to get a portion of that spouse's property or estate.
I wanted to go back to also what the court seems to have taken particular issue with here, Advocate. There was a wording there they took particular issue with, and I just want to quote it, entered into before the commencement of the Matrimonial Property Act 1984. It seems the court is saying that its phrasing was inconsistent, right, with the Constitution and therefore invalid. Just explain for us what the perspective and positioning of the court was in this instance.
Yeah, so what the court done was it says people that were married out of community property without the inclusion of the accrual regime before 1994, according to the law, they can apply for the redistribution of assets. So any spouse that got married before 1984 without the specific regime, they can argue now at the divorce proceedings that I would like to have some assets or some money from my other spouse. That's possible. But what the court's reasoning was as follows: why are we discriminating between people that got married before 1994 and after 1994? Is it legitimate? Is it fair? Is it in terms of the Constitution? So the court basically said was that is unconstitutional. We're discriminating between people that got married before 1994 and people that got married after 1994, and it's not a logical conclusion to apply, or a logical constitutional argument to apply. So the court said now, okay, full stop. If you are divorcing your spouse after 1994, we will not discriminate against you. You can also now apply the principle of redistribution of assets.
I think we once had this conversation before, Advocate, if you remember. There was an instance where, a wife had wanted to claim from their husband during the divorce proceedings because they had mentioned that they believed they had assistance in helping them to grow their estate, in helping them to be where they are. It seems financially they were not where they were before the marriage, but during the marriage they had accumulated, the husband that is, more assets, more wealth. I support the estate has grown, and now that because they're going through a divorce, they wanted to claim a portion to say they had also contributed to the marriage. Will that claim now be successful?
Yes, unfortunately, or maybe fortunately, the Constitutional Court must still confirm the judgment. It's possible, it is theoretically possible that the Constitutional Court might say, I want Parliament to sort this issue out. Or the Constitutional Court might say, I do not think the High Court was correct. However, once this whole matter is finalized and processed, and the Constitutional Court, all Parliament says, tomorrow we're changing the laws, now we're allowing for this new scenario which the High Court has come about with, it would be possible for that specific spouse to argue so. You are 100% right. The basis of the specific court case goes around the issue of many times the wife is the one that stays at home. She looks after the kids. She irons the father's shirt, the husband's shirts. She looks after the household, and many times she most probably leaves her current employment and she cashes in a pension fund and whatever money she has, and she uses it to assist the family, to pay the children's school fees, their clothing, rental, whatever the case may be. Now the husband became very wealthy. He became super wealthy, and the marriage has broken down. It is obviously now unfair for the wife now, because she was the one that married her spouse out of community property, out of cruel system, to leave the marriage with nothing. And that's where the issue of fairness and equity comes in. So if this law does become law, this proposed legal situation becomes law, it will allow for many women who were unfairly treated during the marriage. Of course, a spouse who lived in the pure sense of the word, out of community property, without the inclusion of the cruel regime, where she done whatever she wanted to do with her money, and he done whatever he wanted to do with his money, and they get divorced. She cannot argue that she wants part of his estate, because that would be unfair. But a spouse who has spent energy, time assisting the family in developing wealth, in obtaining wealth, and many times it happens whereby the parties purchase a home, but the home goes in the name of the husband, and the wife spends a lot of energy and time, baking in the kitchen, assisting the family. But at divorce, the law said before the judgment says, the law said that the wife can get nothing from the husband. But hopefully that will change.
All right. Well, of course, we'll have to wait and see. Hopefully we can have you back then, should the law change. Advocate Muhammad Abduroaf, thank you so much for coming onto the show and talking to us about this.